My name is Christina Lawson. I'm the chair of Panel B of the Medical Board of California. It is May 9th, 2019. This is our 9:30 a.m. Open session. If we could please, I'm going to call the meeting to order, and then if we could please have a roll call.
Ms. Lawson?
Here.
Dr. Bolat?
Here.
Ms. Friedman?
Here.
Dr. Gonadev?
Here.
Dr. Kraus?
Present.
Ms. Sutton-Wills?
Here.
We have a quorum.
Thank you. And now we'll move on to oral argument on non-adopted proposed decision, matter of Devon Malecki.
All right. So we're going to go ahead and open the record now. We are opening the record in the matter of the petition for reinstatement of Devon Malecki, case number 800, 2017, 035045. The current OAH case number is 2019 040524. It's May 9, 2019, approximately 9:30 a.m., and we are at a location in Los Angeles, California. My name is Julie Cabos Owen. I'm an administrative law judge with the Office of Administrative Hearings, and I'll be presiding over this proceeding. If I could please have the appearances of the parties for the record.
Thank you, Your Honor. Peter Osinoff, appearing on behalf.
Can you use your microphone, please, sir?
Okay, do I have to continuously press, or is it?
Just press one.
Thank you very much. Peter Osinoff, appearing on behalf of the petitioner, Devon Malecki, who is seated to my left.
Good morning, Rebecca Smith, Deputy Attorney General on behalf of the people.
All right, and I understand that everybody has a copy of the ground rules for the proceedings, but just so that I have them on the record, each party will have 15 minutes for opening argument and 5 minutes for closing argument rebuttal. Respondent will have the first 15, and then the Deputy Attorney General, and then 5 minutes for each after that. Respondent will also have the opportunity to address the panel personally. If that is done, then I will go ahead and swear in the witness to testify under oath. Arguments must be based on the existing record. No new evidence will be heard. And I'm going to ask if, when the panel members ask questions to clarify arguments, that we not elicit any new evidence, and as you ask the questions, if you could please identify yourself for the record first, so it makes it a little easier for the court reporter to identify who's speaking on the record. And then after the argument, the board will go into closed session to deliberate. It's my understanding that no decision will be issued today. So why don't we begin with argument. So, Mr. Osinoff.
Thank you, Your Honor. And good morning, ladies and gentlemen of Panel B of the Board. It was the Board's order in this case that the parties address whether the level of discipline is sufficient to protect the public. The Attorney General's office, in its brief, has suggested that a total abstention requirement be added. And we have no issue with adding a total abstention requirement. Mr. Malecki does not intend to use drugs or alcohol again. He hasn't used drugs in 18 years, except one instance of unintentional use when, unbeknownst to him 8 years ago, someone slipped GHB into his drink. The only issue today, as far as we see it, is whether it's really necessary for the protection of the public to impose the uniform standards for drug-abusing physicians upon Mr. Malecki for his conduct that concluded 18 years ago. He has not only been drug-free, but has completely abstained from alcohol for the past 3.5 years. He had never abused alcohol, but for the past 3.5 years, he has totally abstained from alcohol. During that time, he has enrolled in the PAG, Pacific Assistance Group program. He has had, up to the time of the hearing, 71 consecutive random negative urine samples. He has had no failures to check in on any day. He has had no failures to appear for testing at any time. Marsha Vanover, who is an MFT with a PhD in psychology, is his PAG group leader and has been for the past 3.5 years. And she came to the Office of Administrative Hearings to testify for Mr. Malecki. She had previously been his group leader in the Medical Board's diversion program in 2000 and 2001 when Mr. Malecki participated on that until a positive test led to his dismissal from that program at that time. She came in and testified he is a completely different person. He is much more mature. He is goal-oriented. He is at peace, and he regularly attends AA meetings, too, and has a sponsor. Although there was a contract in which he agreed to have a psychological or psychiatric evaluation, she testified that she determined that based upon her observations of him, there was no need to have a psychiatric evaluation. He has had no need to take antidepressants since 2001. He has had no psychological issues. Since then, he has no need for therapy and has not had therapy. He has found greater peace and balance through the study of Buddhism, and he has been very highly functioning since getting his MBA in 2003. He was never under the influence, except for that one unintentional instance 8 years ago, of anything. And he's been given great responsibilities at work. Since 2015, he's been a consultant for Allergan, doing education and training for preparing curricula for physicians. And from 2008 to 2014, he worked also at pharmaceutical education and marketing for a company headed by Ken Rabatsky. Mr. Rabatsky came to the OAH and testified on behalf of Mr. Malecki about how impressed he was with Mr. Malecki's candor from the outset regarding his drug history, and he found him trustworthy enough to run the business in Mr. Rabatsky's absence whenever Mr. Rabatsky was away. He also testified that Mr. Malecki was always sober, including on a number of business trips that he took with Mr. Malecki. Mr. Malecki has absolutely no desire to use drugs or alcohol, and by the clear and convincing evidence in this case, he has completely rehabilitated from his drug abuse. So I ask, what is the point of imposing mandatory uniform requirements based upon an ancient history of drug use in the face of such strong evidence of rehabilitation? At the very least in this case, if the board feels that it's still necessary to impose the uniform requirements, I would urge the board to rely on the results of a clinical diagnostic evaluation to be conducted by a physician of the board's choosing in order to determine whether and for how long Mr. Malecki needs to be mandated to remain in a monitoring and testing program, given the lengthy history he has demonstrated in this case. I will be very brief and end it there, reserving all of my time for rebuttal, and I thank you very much.
All right, Ms. Smith?
Thank you, Your Honor, and members of Panel B. Petitioner is a substance abusing licensee because of his history of discipline involving the use of illegal drugs. His license revocation in 2002 arose out of allegations that included the dangerous use of controlled substances. Therefore, the uniform standards must be applied in this case. The board needs assurance that he is in fact staying sober. These terms and conditions with abstinence from controlled substances will help ensure this. Optional condition number 9 of the board's disciplinary guidelines must be included to protect the public. He needs to abstain from the use of controlled substances. The other terms and conditions, the clinical competency program, the professionalism program, ethics course, the clinical diagnostic evaluation and reports, notice of employer or supervisor information, biological fluid testing, substance abusing support group meetings, work site monitor, and violation conditions for substance abusing licensees are necessary, appropriate, and comply with the board's disciplinary guidelines and the uniform standards. For his past unprofessional conduct related to violation of Business and Professions Code 2239, and for his unprofessional conduct in misrepresenting his license status in order to generate certificates of completion, certificates for completed continuing medical education to include in his petition of reinstatement. 5 years probationary term is reasonable. We don't know if he can handle the stressors of being a physician again. The public needs to be protected while providing petitioner the guidance necessary to ensure a safe re-entry into the practice of medicine. And as Dr. Vanover, his monitor with Pacific Assistance Group, testified at hearing, as long as he continues doing what he is right now on a daily basis of practicing his recovery, the prognosis is good, but he has to keep in mind that this sobriety is one day at a time. He has a substance abuse disorder that's in remission. He needs guidance in the form of probation. Oversight by the board is an additional assurance that respondent will stay true to his vow of sobriety. And lastly, I would also like to request, with respect to the standard terms and conditions, in addition to the restriction of supervising PAs, that restriction also include advanced practice nurses, which is consistent with the board's disciplinary guidelines, standard condition number 28, that during probation, respondent is prohibited from supervising PAs and advanced practice nurses. I believe advanced practice nurses was omitted from the proposed decision and should be added. Thank you.
Are you reserving the remainder for
Yes,
rebuttal?
Your Honor.
Mr. Osinoff?
Thank you, Your Honor. This has been a lengthy, a very lengthy recovery, a lengthy period of remission. If the board has any concerns, I would just urge the board to be guided by the DCE, the Diagnostic Clinical Evaluation, that will be done in this case. As far as misrepresenting the license status, there was no misrepresentation of a license status. In doing the online CMEs, there was a drop-down menu asking, are you a doctor, nurse, whatever, and he selected from the drop-down menu that he was a physician. He didn't represent that he was in active practice. The nature of his specialty or practice was once described as general practice, another time or two as anesthesiology, because he had been in an anesthesiology residency. But there was never a misrepresentation that he was at that time actively practicing, and it was his drop-down menu just that he had to fill out for the purpose of providing feedback to the CME company that was running this, so he could get a record of his CME, so we could present that to the court. That's all that was involved in that. Otherwise, everyone at the hearing testified about his candor, his honesty, his integrity throughout. The earlier dishonesty in diverting and changing medical records in 1999 to 2000 was a result of his drug use, and that has no sort of dishonesty has manifested itself since then. In any event, he's had quite a bit of support from the people for whom he's worked, the people he's had business relations with, have all testified about how what a man of morals and honesty and integrity that he is. And he's never held himself out in any context as able to practice medicine, never never attempted to do so. He's been very careful about that for all these many years. So, with that, I submit that we have no problem with adding the nurse practitioners to the standard, what is the current standard since 2016, term and condition. No issue with that. I just would urge this court to be guided, as the board, to be guided by the DCE that's going to be done in this case. I thank you very much.
And Ms. Smith, anything in rebuttal?
Yes, thank you. Petitioner has taken responsibility for his unprofessional conduct and has provided evidence of rehabilitation. Notwithstanding, the board has a statutory duty and obligation to protect the public. It's not only is it appropriate, but it's necessary to place Mr. Malecki on probation with specific terms and conditions as outlined earlier, not to punish him for his lack of judgment, but to protect the public. And there is a secondary benefit to addressing this danger, even with his lengthy recovery while he's not been practicing medicine. The board will be aiding in Mr. Malecki in his sobriety and continued rehabilitation. He does have a substance use disorder that's in remission. Just because he says he's in recovery and won't do it again, that doesn't mean it's true. He does need guidance, and he needs oversight by the board as an additional assurance that he will stay true to his vow of sobriety. Thank you.
Were there any panel members that had any questions? If you could identify yourself for the record before you do ask any. All right.
Thank you, Judge, and maybe you can swear in Mr. Malecki who wants to answer.
All right. Sir, if you could raise your right hand and be sworn. Do you solemnly swear the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And if you could move the microphone.
Yes, I do.
All right. And this is Dr.
Dr. Ganadev. 17 years of practice is not, medical practice is not riding bicycle. So what are your plans in future if you get your license back? And have you looked at actually doing some refresher of 6 months to a year to really get into medicine again? Doing CME courses alone does not keep a physician to be a physician.
Thank you for that question. Over the past 16, 17 years, on a daily basis, I read the medical literature just because of my job roles and responsibilities, so I have kept abreast with not only basic knowledge, but more advanced knowledge to keep in line with some of the key opinion leaders within the different specialties. Regarding my future plans, I definitely would like, I'm willing to be partaking in the PACE program. In preparation for the PACE program, I will be reviewing some of the basic medical textbooks in general practice to prepare for their examination. And in terms of additional training, I will be partaking in additional clinical training, especially in the field of aesthetics that I want to pursue. That's what I do right now from a curriculum standpoint. So absolutely, yes, I plan on keeping reading didactic and also having some clinical training within the next year to get introduced back into clinical practice.
Any other questions?
Hi, Brenda Sutton-Wills. I do have a question. Given that counsel stated that you don't have a problem with the shortcomings outlined by your opposing counsel in terms of monitoring, it says if you've said them both, that you do have a problem with monitoring and you don't have a problem with monitoring. So can you just clarify where you are? Well, actually, I'd like to hear from the doctor, please.
That's fine.
Sure, yes, absolutely. I have no objections to being monitored over an extended period of time with random drug screens. I have a fairly strong recovery program as it is, and as Marshall mentioned, it's a day at a time, and that's what I practice every day with every aspect of my life. I meditate on a daily basis. and I have a very spiritual aspect to life, and in terms of retrospection, in terms of monitoring, yes, absolutely.
And then with regard to abstention, you said there was no objection, but then counsel stated that there needs to be an examination to show how long that should be, and what, I guess the inference there is that there's some problem with the term of probation being the duration of the monitoring, and I just want the physician to talk to us about that.
Sure. No, I have no objection in terms of the duration of the probation and abstinence from any kind of drugs or alcohol. Absolutely.
Thank you.
And if I may also, I was not suggesting that he would not abstain or that we were objecting to that. The only question I had is, in view of the 3.5 years of monitoring and testing that have gone on at this point, how much longer does he need to do that? And I would urge the board to be guided by whatever the clinical diagnostic evaluation determines is appropriate for that, for his recovery. There is a 5-year contract that he signed, which is typical of a recovery program, and after 5 years, is there really more need for monitoring and testing at that point? That's all I was suggesting.
Oh, I understand. Thank you.
Thank you.
Any other questions?
I'm wondering, how will having a license change?
Oh, I'm sorry, if you could turn your microphone on. And this is Ms. Friedman.
Yeah, sorry. I'm Susan Friedman. Mr. Malecki, how will having your license change what you are doing now, since you've said you don't intend to have patients?
Sure. Thanks for that question. At the moment, I don't obviously have a practice. All of my focus is on the pharmaceutical space in terms of developing curriculums for other physicians to actually do the training and education. Eventually, if you guys permit me to have my license back, I will be starting to practice to get the clinical training I need in this space. And at the same time, not only I will be able to develop the curriculum, but actually train other individuals in this space, like some of the other physicians and also some nurse practitioners that do the live training. So I do plan on seeing patients. There will be a transition that will be part-time in terms of how many patients I see from a clinical standpoint versus actually still continuing to do what I do. There's a lot of physicians with active licenses that do what I do, but at the same time they see patients in clinical practice and also do the live training and educating their peers in how to do these advanced techniques or any other curriculum. I don't know if I answered your question.
I wasn't sure whether you plan to see patients.
Yes, I do plan on seeing patients.
Any other questions? All right, so if there's no further questions, then the matter is submitted and we're off the record.
Thank you for your time.
Thank you.
Thank you, Your Honor.
Yeah, the panel will go into closed session now. Of the Panel B meeting agenda, oral argument on non-adopted proposed decision.
All right, so we're going to go ahead and go on the record. We are opening the record in the matter of the accusation against Michael Aurash Zadeh, case number 800, 2015, 015-340. Current OAH number is 2019, 040-523. It is May 9th, 2019, 10:45 a.m., and we are at a location in Los Angeles, California. My name is Julie Cabos Owen, Administrative Law Judge with the Office of Administrative Hearings, and if I could please have the appearances of the parties for the record.
Good morning, Your Honor. Rebecca Smith on behalf of... Can I get you use your microphone, please? Thank you. Good morning, Your Honor. Rebecca Smith, Deputy Attorney General on behalf of complainant.
Good morning, Your Honor, and members of the panel. Once again, I am Peter Osinoff, and I represent Dr. Michael Zadeh, who is seated immediately to my left.
All right, and we have both the same counsel as from this morning, so I won't go over the ground rules again. We'll just go ahead and proceed to the arguments. Again, 15 minutes each, and then the 5 minutes for rebuttal. Thank you. Go
ahead.
Yes.
Thank you, Your Honor, and Panel B. The non-adoption of the disciplinary terms of the proposed decision in this case is appropriate and consistent with the evidence. In order to comply with the board's statutory duty to protect the public, respondents should be placed on probation with specific terms and conditions. Specifically, the following disciplinary orders should be imposed in this case: revocation of respondent's license stayed, probation for a minimum of 5 years at least, education course, professionalism program ethics course, and a practice monitor, as well as standard terms and conditions. Respondent permitted unlicensed medical personnel to perform multiple physician tasks at his med spa. They performed consultations for cool sculpting and laser hair removal. They performed cool sculpting, and he permitted patients to purchase prescription-strength skin products from unlicensed personnel without the patients being seen or evaluated by respondent. There were 2 undercover operations that established that respondent was aiding and abetting the unlicensed practice of medicine. He admits that the illegal conduct subjects his medical license to discipline, and in fact, in November 2018, he entered into a factual and evidentiary stipulation where he fully admitted both causes of discipline set forth in the accusation, and he reserved his right to present evidence and argument at hearing regarding the appropriate discipline. The administrative law judge erred in recommending that respondent be issued a public reprimand with the requirement that he enroll and complete a course in non-surgical cosmetic medicine and provide the board with all written policies and procedures adopted after his arrest for all procedures performed at his med spa. The ALJ incorrectly concluded that a public reprimand was appropriate since respondent did not intend to violate the Medical Practice Act. He has made efforts to change his practice at his medical spa, and his reputation as in the surgical community would be negatively impacted by oversight through probation. This lenient sanction of a public reprimand is not supported by the evidence presented at the hearing and places the public protection at risk, provides for no oversight or safeguards to protect the public. Here, the facts and circumstances mandate a period of probation with monitoring. The discipline in this case should be tailored to protect the public from a doctor who claims to have been unaware of his responsibilities as a physician and surgeon, and at the same time calculate to aid him in his continued rehabilitation to ensure a lapse in judgment will not reoccur. The proposed decision departs from the disciplinary guidelines without justification. The chief purpose of the Medical Practice Act is public protection. Ignorance and failing to understand the parameters of the use of unlicensed individuals in his med spa practice place public health, safety, and welfare at risk. Probation with monitoring will provide the necessary oversight to ensure public protection. Respondent allowed unlicensed individuals to practice medicine, and he failed to provide adequate assurances at the administrative hearing that he will not allow it to happen again. After his arrest, he hired an attorney to assist him with compliance aspects of his practice, and he said that in the future he'll call the lawyer should there be an issue. He's provided no assurances that he's capable of recognizing issues that would require legal counsel. He testified that since his arrest, he's created policies and procedures for his office, but he has not produced any of those at the hearing. Just because he says it'll never happen again does not mean that that's true. It shouldn't have happened in the first place. He needs guidance in those gray areas where he has been unable to independently differentiate between right and wrong. With respect to the impact of probation on his pecuniary interests, it does not outweigh the need for monitoring. Respondent testified that his surgical practice will be impacted if he's placed on probation, and the proposed decision sets forth that his reputation in the surgical community would be negatively impacted by oversight through probation. His character witnesses testified that he's a competent surgeon. Significantly, his surgical practice has oversight. There are hospital rules in place, there are hospital regulations in place, and there are bylaws, and he has a chief of surgery and a chief of staff that provide oversight and guidance for his surgical practice where he has no problems. Respondent's med spa practice does not have a fail-safe in effect. His character witnesses all testified that he's remorseful for not knowing the rules and regulations for a cosmetic practice. They chalk it up to his inexperience and ignorance. There is a risk that the public will be in danger if respondent's non-surgical cosmetic practice is not monitored. It's already been established that he was unable to differentiate right from wrong when he self-regulated his practice. The harm to public health, safety, and welfare, leaving him unrestricted and unmonitored, far outweighs the harm to his pecuniary interests. It's only appropriate and necessary to place him on probation with specific monitoring requirements so that the public is adequately protected against any similar misconduct by respondent. Thank you.
Are you reserving the remainder?
Yes, Your Honor.
Mr. Alstinoff?
Thank you, Your Honor, and members of the panel. This case is very different from other aiding and abetting the unlicensed practice of medicine cases. This is not a case where a doctor loans his license essentially to a med spa that's owned by non-physicians. This is not a case where a doctor fails to be present or fails to supervise or train his personnel. Dr. Zadeh is a board-certified general surgeon who owned and owns 100% of the Z Center for cosmetic procedures where this occurred. Even the fictitious name permit was properly obtained by him. He trained his staff there extensively. There has never been a patient complaint, and there is not any patient harm. This case started with an anonymous complaint that he allowed non-licensed personnel to operate a cool sculpting device, which isn't really an issue. Even the board's own expert witness says that an MA or assistant can operate the device. It's just a matter of applying a suction-like device to the patient. There are no manual setting adjustments. Dr. Zadeh, I should add, did all the Botox and filler injections himself. Not a nurse, not anyone else. He did all that himself, all throughout the 5 years that he has had this cosmetic practice. He has done all laser resurfacing and laser skin tightening procedures himself. He had no intention, as you've heard, he had no intention to commit the violations. He wanted to follow legal requirements. He got it wrong in certain ways, and early on, from the beginning, admitted that he did and made changes immediately upon those being called to his attention. He would have been very responsive to a letter from the board, as he was responsive immediately after the undercover operation that resulted in his arrest. Now, what were the violations that were discovered in this case? Well, his RN, who did all the laser hair removal procedures, and appropriately did so, and within the course of her scope to do so, and did those procedures after training by the manufacturer and training and observation of her doing the procedures by Dr. Zadeh. But the issue was that she did the evaluation of the patients for the procedure if they wanted hair removal. And if there were any unusual or abnormal skin issues, she had Dr. Zadeh evaluate all of those patients himself. Otherwise, the RN would proceed. And at all times when she was proceeding with a laser hair removal, Dr. Zadeh was always present in the office. In fact, he was present during the entire time of the 2 undercover visits, in this case at the beginning of 2017. The second issue is a skin cream containing a prescription drug strength of one ingredient, hydroquinone, they called it Brighton, was recommended by the licensed esthetician a total of 8 times in the 4 years without Dr. Zadeh himself seeing the patient. Now, even when Dr. Zadeh didn't evaluate the patient himself, as was the case here, where the undercover agent came in and said, "I've had this before, it's been fine," there was an adequate history taken by the licensed esthetician, and the case was discussed with Dr. Zadeh before the recommendation for Brighton was made. In fact, the evidence was that she left the room, and then when she was out of the room, they discussed the case, and then she went back and recommended the Brighton. The third aspect is the cool sculpting recommendation was made without Dr. Zadeh having seen the patient. But again, Dr. Zadeh was always present during these procedures and saw the patient during the time that the device was applied and used in every case. The only indication for cool sculpting is unwanted belly fat. That's not a difficult diagnosis or evaluation, and Dr. Zadeh did not think that a doctor's recommendation was needed to apply that device. And finally, an unlicensed person did dispense a refill of Brighton, apparently mistakenly thinking it had been authorized by Dr. Zadeh, but in any event, without Dr. Zadeh's knowledge or permission. He was in the office at the time, but wasn't consulted regarding that. Dr. Zadeh took responsibility for these violations. He pled no contest to aiding and abetting the unlicensed practice of medicine by allowing the dispensing of a topical cream with a prescription strength ingredient without his prior examination, although he was at all times in the office. And immediately after the arrest in February 2017, following the undercover operation, at that time, as you've heard, he promptly hired an attorney to ensure his future compliance. For the past 2 years, the evidence was that he has done every evaluation himself for every medical treatment or device prior to any recommendation for such treatment or device. But he went a step beyond the legal requirement. Only he or the RN apply the cool sculpting device suctions. Although an MA could do so, he doesn't allow anyone else other than himself or the RN to apply that. And again, he does all of the evaluations of every patient himself. And he does so before the RN performs laser hair removal. He does all the evaluations himself. Yes, she has some unwanted hair, and no, he or she doesn't have any skin condition that would contraindicate the laser hair removal. He does the evaluation himself before recommending any Brighton cream, which he himself dispenses to the patient. And he did community service, and he paid the board's investigation costs for its undercover operations in this case. That resulted in the criminal court allowing Dr. Zadeh to withdraw his no contest plea, and the court and the DA's office agreed that the criminal case should be dismissed. They didn't want to derail his career as a board-certified surgeon in particular by pursuing this criminal prosecution. Now, public protection is this board's paramount concern. but to the extent not required by public protection, Section 2229 of the Business and Professions Code requires that the disciplinary action aid in the continued rehabilitation of the physician and not destroy their careers in doing so, because that would not aid the rehabilitation of a physician. In this case, what is there to be monitored? There was nothing that was done wrong other than he did not, for certain procedures, evaluate the patients personally. There has never been an issue as to how the cosmetic procedures were performed. The standardized procedures and protocols, they have to do with how to perform the procedures and the like, and so they're not really that relevant to the case. I mean, the proposed decision says we should produce them within 30 days of the effective date, and of course Dr. Zadeh is prepared to do so. I have them right here, in fact. Standardized procedures about every treatment that's done in the office. But he doesn't employ a nurse practitioner or a PA in his office, doesn't supervise those, so there's no delegation of services agreement. There are no standardized procedures and protocols for the nurse practitioners. And there's never been a significant risk of harm to patients, much less any actual harm in this case. The board shouldn't act in a manner that would put Dr. Zadeh's board certification as a surgeon in jeopardy, which would end his career as a surgeon. The testimony and the evidence in this case and the witnesses who came forth to the OAH showed that probation would destroy his career as a surgeon. The witnesses included the chief of surgery and the former chief of surgery at Valley Press Hospital, who both testified that Dr. Zadeh would lose his privileges if his license were placed on probation. On the other hand, there is no risk to the public if he were not subject to probationary terms. I've asked myself, what is to be gained by a probation monitoring when he's now doing all the evaluations himself for the last 2 years? What more needs to be done? Now, while we have no objection to any educational courses or those common terms that accompany a public reprimand, reporting to a probation monitor or to a practice monitor would serve no function to protect the public. There's no issue as to his evaluations. His office, there's no reason to mistrust his testimony under oath that he's been doing them for 2 years. The board can, of course, come in and do an undercover investigation and check that out, but there's no reason to doubt that, and no one does. He presents no risk at all. In fact, he's probably now more knowledgeable than almost any other physician about the scope of practice rules, and more knowledgeable than any other physician probably can be, based upon the experiences that he's been through already. The only function of a probation would deprive the public of the skills and talents of an excellent surgeon. The testimony was he was entirely competent in his surgery practice and an excellent, skilled surgeon, ethical, honest, and a man of integrity. And about 60% of his practice is a surgical practice. In fact, he moved his surgical practice early on. He moved his surgical practice into the Z Center, so he's always there whenever any treatments are occurring, and he's always there to see the patients. So I would urge this board not to overturn or change the decision of the administrative law judge who heard this case, heard from Dr. Zadeh in the case, heard Dr. Zadeh's remorse and sincerity, and there's no reason to doubt that he's doing the evaluations of all patients who come into the practice. And so if he were placed on probation, that would only have the effect of reducing that part of his practice, the surgical practice, which we would not want to deprive the public of. Thank you very much.
Thank you. Ms. Smith?
Thank you, Your Honor. First, I'd like to interpose an objection to consideration of the policies and procedures as being outside of the scope of the administrative record. He did not produce any policies and procedures at the time of the hearing. He said he had prepared them after his arrest, but he didn't bother bringing them to the hearing. It is undisputed that he allowed unlicensed individuals practice medicine. It just wasn't one area. They provided consults for cool sculpting. They provided consults for the laser hair removal. They provided consults for providing prescription strength medications, and they dispensed the prescription strength medications. It's not important that he didn't cause patient harm. He placed patients at risk for harm and injury. Public protection is this board's #1 priority. We don't know if he'll do it again, and we do know he probably won't recognize that he's doing something wrong until the board comes in and tells him he's doing something wrong. It has been established that he aided and abetted the unlicensed practice of medicine and has placed patients at risk. His misconduct demonstrates professional irresponsibility. The proposed decision falls short of providing public protection and fails to provide safeguards to ensure his compliance with the Medical Practice Act. He has oversight with respect to his surgical practice, but he does need guidance and oversight by the way of probation and monitoring with respect to his med spa practice, and in doing so, he will be adding to his rehabilitation. Thank you.
Thank you. And again, Mr. Osnoff?
Thank you very much. So why would he not recognize at this point, after he was promptly educated at the time of the undercover investigation when that was revealed to him, and it was absolutely clear to this very intelligent surgeon what he needed to do at that point, and what he didn't need to do, and he promptly implemented it by seeing every patient himself. So the policies and procedures we didn't introduce at the time. They just had to do with how the procedures are performed, and I'm happy to not introduce them now, but we're happy also to follow the order of whatever order there is for him to produce these at this point. There was no reason to introduce how these procedures are performed. There was no issue of poor performance of any procedure in this case at all, ever. This board should not, in fact, it's directed not to impose probation for punitive purposes. The criminal court decided that, and the DA's office decided not to be punitive in their case. This board should not now step in and be punitive by imposing a probation for the conduct that it really entailed minimal risk to any patient in this case, and there is no reason at this point to impose a monitoring, because absent someone standing in the office at all times, there is I don't know what monitoring would determine whether Dr. Zadeh is complying with the Medical Practices Act. He's certainly well aware of the Medical Practices Act and the requirements and how to interpret it at this point, and has been from an early date, acknowledged from day one his wrongdoing, and quickly took steps to correct that and even go beyond what was required. So in this case, the probation merely has a punitive and not an ameliorative effect on Dr. Zadeh, and would adversely, as I've argued before, affect the public by depriving the public of his surgical skills. Thank you very much.
Thank you. All right. Does anybody have any questions? And if you could identify yourself for the record. Dr. Krause?
Howard Krause. Mr. Osnoff, I'd like to clarify something which is stated in your April 18th respondent's argument after non-adoption, and which you touched on today. In Section 5, you write, a disciplinary probation would have the unintended consequence of prohibiting Dr. Zadeh from practicing as a surgeon. And you further note Dr. Zadeh testified that probation could result in the loss of his board certification. He is correct, as the American College of Surgeons, which certifies general surgeons, considers probation as an expulsion-level offense. In that same paragraph, you note, in a domino effect, the loss of board certification may result in the loss of surgical privileges at his primary hospital. As Dr. Malecki explained, surgeons who lose board certification cannot work at Valley Pres anymore. They cannot work at Mission Community anymore. They cannot take calls. They have to resign. It's my understanding that the American College of Surgeons is not the ACGME board certification of surgeons, but rather it's the American Board of Surgeons.
That is correct.
So,
I erred.
in some regard, this could be viewed as misleading.
I am sorry, I did not notice that.
And there's no evidence that his board certification from the American Board of Surgeons would be in jeopardy by being on probation.
I understand that. You are correct. It should be the American Board of Surgeons, and I stand corrected, Dr. Krause. I apologize to this panel. I was the American College is, as I understand it, is not the American Board, but it's my understanding that the American Board also has the same issues, and there was testimony, I believe, to that effect, that he would lose his board certification. But this section, you are absolutely right. It should be the American Board of Surgery, and that is my understanding that the American Board of Surgery has the same prerogative to discipline its physicians who are on probation.
But yet there's no evidence presented to state clearly that the American Board of Surgery would remove his board certification if placed on probation.
Other than what was testified to in the hearing, there is not. I don't believe that there was evidence on that. You are correct. And I'm sorry for that oversight, and I did not intend to be misleading. I take responsibility for it. It wasn't signed by me, but I take responsibility for it. And I should have noticed that. If I may have the opportunity to submit to this panel the American Board of Surgery bylaws that are relevant here, that I think would clarify the issue, and I would do so within one day.
Your Honor, I would like to interpose an objection. At the hearing, there was no testimony regarding the American Board of Surgery. It was only the surgical college as referred to in his paperwork.
No, I don't think so.
All right, and what section are we looking at?
Section 5. And I believe he had attached, as an attachment to the American College of Surgeon bylaws. And there was no testimony regarding the American Board of General Surgery at hearing. And as we all know, the American College of Surgeons, that's you're not tested in. You pay your membership fee. It's more of a membership than certification.
All right, well, I don't have the entire record in front of me, but from what you're saying, the citation to the American Board was not in the record, and so the objection would be sustained, because then we would be including something in the record that was not included in it previously.
Yes, if I may, I think the record was that the hospitals themselves would look at the probation and not allow someone on probation to be at Valley Pres. hospital. I believe that that was the testimony, and I think Dr. Krause was correct on that. I think that's what you're indicating. It was not a reference to the American Board of Surgery, but to the hospital action itself that would be taken.
Well, again, I didn't see the full record, but in the quotation of the record in your response, you note that the hospital requires board certification.
Yes, I see.
It doesn't secondarily note what the hospital would do with regard to a physician on probation. I would suspect that that would be on a case-by-case basis.
I think that's correct. I would say it puts it in jeopardy, but there's nothing that's an absolute certainty either way.
Any other questions?
Would the board care that I submit at this point anything, the bylaws from the American Board of Surgery? Would that clarify anything?
All right, and I understand there was an objection because that was not part of the record, and so that objection was sustained, so that we do not consider anything that was outside of the previous record.
American Board of Surgery is aware, though. I submitted everything to them.
We have a question from Ms. Sutton-Wills.
Hi, Brenda Sutton-Wills. Can you just have a run at that, telling us again what, I'll give you a new run at what is the risk to his practice, now that you've had a chance to think this through? Just give me a contained statement of what the risk to his practice of this probation would be then.
Okay, the risk to the practice of the probation is that would be his inability to practice surgery in a hospital context based upon his probation, which is considered on a case-by-case basis. I would say that I would note that during the time the criminal case was pending, that he was placed on leave from Valley Press, and so the hospitals do take this quite seriously. My understanding is that there is always the potential for loss of a board certification, and if that occurs, then that would put his ability to practice in the hospital in great question, because many of them do require board certification. But even if they don't, they have the option of not continuing to allow Dr. Zadeh to practice surgery on the medical staff. Yeah, apart from the definite loss of certain insurance contracts, which, for example, Blue Shield is automatically takes any physician on probation off of its panels of member physicians. Many others terminate them and then decide the issue on a case-by-case basis on appeals to them, like Blue Cross or Cigna do have individual case-by-case determinations, and an appellate system. Blue Shield does not. You're automatically off if you're on probation with Blue Shield. So that would have an effect, I presume, on hospital call panels. And the ability of the doctor to take calls, if he cannot accept payments from various insurers. So it does have a snowball effect in any case.
Thank you.
Thank you.
Any other questions? All right. There being no objections, or excuse me, no further questions, then the matter is submitted and we're off the record.